The Divorce, Dissolution and Separation Act 2020 was given royal assent in June of last year and comes into force in April 2022. What this does is means that parties can proceed with a divorce based on the marriage having irretrievably broken down without having to allocate blame or wait for a period of 2 years. The landmark case of Owens versus Owens in 2018 has played a huge part in these reforms. Mrs. Owens petitioned for a divorce based upon Mr. Owens' unreasonable behaviour. Whilst the court accepted that the marriage had irretrievably broken down, Mrs. Owens had failed to establish that this was as a result of Mr. Owens' unreasonable behaviour. Therefore, Mrs. Owens had to remain married to Mr. Owens until the parties had been separated for 5 years. The courts recognised that this was wrong, but it was not within their powers to change it, and therefore it would pass back to Parliament to make the necessary changes to the law. The reforms are seen as important because in modern family law, parties are very much encouraged to try and reach an agreement between them and take a collaborative approach. This has long been reflected in both finances and children matters, and it's high time that it's also reflected in divorces.